Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. Today I want to talk about a question that keeps coming up. It wasn't what I was planning to do for my next video, but it came up on the Canada Gun subreddit, so I thought I'd address it. It's a bit about the case of the Queen in Felawka, which is one of the worst Supreme Court decisions. Certainly in the firearms field, it's just a bad decision. I am not a fan of it. Let's go and have a look. This is actually from the majority portion of the decision, which is the portion of the decision that won the day, and thus is law. Felawka is a case that has been cited over 100 times, so it's a case that does a lot of work. It's a foundational case, if that makes some sense. However, it's a really bad case. It's also a really big meal in the sense that there's a lot going on to it, and if I wanted to cover all of the issues with Felawka, this would probably be a 3-hour video. So I'm going to break this up into several portions. If you enjoy this content, please like, share, and subscribe. But let's get on with the case here. So this is the factual backgrounds. This tells us what was found at the trial court level and what the actual circumstances are that the court is using to make its decision. So Mr. Felawka held a valid firearms acquisition certificate. We know that he's got a license. That's a good start. In April 1988, he took his .22 caliber rifle and went shooting with a friend outside the town of Hope, British Columbia. He stopped at the friend's house in Burnaby on his way home. This is actually around where I grew up. When he decided to return to his own home, he took public transportation in the form of the SkyTrain. If you don't know what the SkyTrain is, it's basically a subway, except it's elevated up on a elevated sort of track so that it doesn't go underground, it goes over and above things. But it's basically a fancy subway. When he got on the SkyTrain at Metrotown is a mall, he was carrying the rifle wrapped in his jacket. He did this because he felt it was not proper to carry his rifle openly. And if we stop and think about what would have happened if he's carrying it openly, people would not have been happy with that. However, 2 passengers became alarmed. They notified a SkyTrain employee that Felawka appeared to be wearing fatigues and carrying a gun. So he wasn't concealing it very well, apparently. Mr. Felawka, as it turned out, was not wearing fatigues, but green-colored work clothes. When the SkyTrain employee asked the appellant what he had in his jacket, he laughingly replied that he was going on a killing spree. The trial judge accepted the appellant's evidence that he made this unfortunate comment in jest. We see that he then gets on a bus, and 3 plainclothed officers boarded the same bus around 11:30 p.m. They went to the back of the bus where he was sitting. When one of the officers called out city police, he appeared to reach for his rifle. The officers drew their revolvers and arrested him. Revolvers, okay. That puts us back into the historical context here. This episode might have had tragic consequences. Yeah, he could have been shot. This is evidenced by the fact that there was a clip, probably not a clip, with 1 live round in the rifle, and Felawka was carrying another clip, again, probably not a clip, with a live round in his pocket. The clip magazine issue is giving us a little bit of a window here that the court probably is not as aware of what they're talking about. For those of you who aren't sort of big gun owners, clip and magazine they're different things. And the improper use of the term interchangeably or confusing the terms is often sort of a canary in the coal mine that you're about to see some things that where somebody's making arguments based on not really understanding guns. So that's our first starting point here. The appellant was charged with 2 counts. First, with carrying a weapon for a purpose dangerous to the public peace, and secondly, with unlawfully carrying a concealed weapon. So he's got 2 charges at the trial level. Looking at what the trial court did, they noted the trial judge acquitted the appellant on the first count of possession of a weapon for a purpose dangerous to the public peace. He found that the appellant's statement that he was going on a killing spree, although foolish, was made in jest. He was not convinced beyond a reasonable doubt that Felawka was reaching for his gun when the police confronted him, Rather, he thought that it might have been a natural reaction for Felawka to move towards his right in order to get away from what he took to be the danger presented by the 3 plainclothes officers. There was then no evidence that the appellant had any intention to use the weapon for a purpose dangerous to the public peace, and that charge was dismissed. Stopping for a moment just to consider a little bit about Mr. Felawka here, he's what you might call what a lawyer might call a moron, because this is an extremely stupid decision. Telling them, oh, I'm going on a killing spree. Had he not said that, he probably wouldn't be in the trouble he's in. And we probably wouldn't be dealing with the aftermath of this. A lot of people are inclined to dismiss this case. They say, oh, it doesn't matter to me because this guy was being such a jerk, because he was making comments about a killing spree. Unfortunately, the Supreme Court doesn't really rule on just a single issue usually. This case has set the law, and it applies to all of us now. So we're stuck with this. We're stuck with the impact that this case has had. Unfortunately, as we'll see. They note, however, the trial judge did find the appellant guilty of carrying a concealed weapon. He held that the only intent required to establish the offense was that the appellant intended to conceal the weapon. So not that you intended to conceal it for a bad reason, but just that you intended to put it in a place where it's hidden. Now, this is a little bit of discussion about the appeals court. I'm going to skip over that because it's not the hugest importance here. It's discussing the procedural history here. I'm also skipping over some issues about discussion of what is and isn't a weapon. I'll get to that in another video, but again, I don't want this video to be 3 hours long. So they go on and say, what then should be the requisite mens rea, which is the guilty mind. It's the mental element of the offense. What you had to have intended to do in order to commit the crime. Perhaps a solution can be arrived at by considering the aim or object of the section itself. There is something extremely menacing and intimidating about the presence of a naked weapon. Maybe. I suspect that they're not entirely wrong here. If he'd gotten onto the SkyTrain with the gun just in his hands, he's carrying it around I suspect that would have gotten a lot of people's dander up. Fair enough. That's all I can really say about that. But they go on to say there's something even more sinister in the presence of a concealed weapon. If we stop and think about that, that's a big maybe. Because people may have different reasons to conceal something. So we'll come back to that a little later. No doubt the legislators enacting Section 89 believed that weapons are usually concealed by persons on the way to commit crimes or after leaving the scene. Come back to that later too. Clearly then, one of the goals of the section is to discourage the prospective bank robber who might be apprehended on the way to the bank with a sawed-off shotgun concealed in his pant leg. Yet, I think the section has a wider aim. All Canadians have the right to feel protected from the sinister menace of a concealed weapon. Note the language here, sinister menace. If it was ever thought that it was lawful to carry concealed weapons, more and more Canadians might come to believe it would be prudent for them to carry concealed weapons in order to defend themselves and their families. Wouldn't that be horrible if people were defending themselves and their families? What a horrible thing. We have to prevent this. Otherwise, people might just be getting injured by criminals. We can see the attitude here. It's not an attitude I really appreciate or approve of, but that's the one the court took. This might lead to a vigilante attitude that could all too readily result in an increase in violence in Canadian society. To my mind, there's a huge difference between vigilantism and self-protection. If I hear that the guy down the street broke into a house and I go over there with a shotgun to teach him a lesson, that's vigilantism. If he's breaking into the house, to my house, and I grab a shotgun because I'm afraid of what he's going to do, I'm not so worried if he's taking my TV, I can replace the TV. But if he's coming in because maybe he's angry at me, maybe he's on drugs, maybe he's dangerous in some fashion, I don't want him to be coming after me to do violence. That's not vigilantism. That's just self-protection. The way the court here is conflating the two, I'm not a huge fan of that. Canadians are well satisfied with the security provided by the close regulation of the ownership and use of firearms. They have every right to expect the concealment of weapons would also be prohibited or properly regulated. To fulfill the aim and object of Section 89, it would then appear that the requisite intent or mental element should be that the accused intended to hide from others an object he knew to be a weapon. So not that you intended to hide it for any bad purpose, just that you intended to keep other people from seeing it. That's what they're saying the mental element for this is. There is much to commend that approach to the mental element, he says without any explanation. Yet there are complicating factors. For example, hunting rifles and shotguns must be carried to and from the hunt camp. Many of the provinces have regulations regarding the transportation and carrying of guns for hunting. For example, the Ontario Fish and Game Act, which provides, in a locality that game usually inhabits or in which game is usually found, no person shall have a firearm in his or her possession unless it is unloaded and encased between 1/2 hour after sunset and 1/2 hour before sunrise of any day. This is a provision that essentially says you can't be hunting except during certain hours. And so if you have a firearm, it's got to be encased when it's not in those hours so that they know you're not hunting, because you're obviously not hunting if your gun is in a box. They go on to talk about the Nova Scotia regulations, but we'll skip over that. As a general principle of Canadian statutory interpretation, where a valid federal statute is in conflict with a valid provincial one, the doctrine of paramountcy renders the provincial statute inoperative. However, where it is reasonably possible to do so, courts will avoid interpreting the statutes as being in conflict. What this means is that if the province and the federal government each make a law, and if we imagine a somewhat ridiculous example, if the federal government said it is forbidden to wear hats on Sunday, and the provincial government said it is mandatory to wear hats on Sunday, because these two laws are something that you can't comply with both, the federal statute would trump the provincial one and would apply. But if it's possible to do both, then they both just apply concurrently. In this area of the law, the regulations of firearms is not monolithic. They are controlled by a variety of statutes for a variety of purposes. At the federal level, the grave danger posed by guns means that firearms regulations come within the scope of the criminal law power. At the same time, provincial regulations pertaining to hunting with firearms are within the purview of the provinces as a matter of local interest. We are therefore in a field where both levels of government have a legitimate interest and an overlapping jurisdiction to regulate. The mere presence of provincial restrictions on firearms does not therefore create a paramountcy problem so long as the two sets of enactments can be reconciled. They're going to explain how they're going to do that. So now they start talking about how we can reconcile regulations that require you to conceal a firearm or to encase it with the prohibition against carrying a concealed weapon. And this is where the court starts to get really interesting. At a practical level, a gun case is a commonplace item that generally proclaims to all exactly what it is. In a great many instances, a gun case is sold with a hunting rifle or shotgun. Indeed, it is difficult to imagine that a gun owner would not transport his or her gun in a case to prevent it from rusting and eventually malfunctioning. Just as an aside here, most cases promote rust as opposed to preventing rust. The foam inserts in a gun case are typically not a good thing to leave your gun in long term. A gun does just fine being transported on its own, so long as you're not burying it in the back of a truck full of sand or something. And even then, a lot of guns will function just fine being pulled out of a bunch of sand. So it's difficult to imagine that a gun owner would not transport his or her gun in a case. Go to any range. You'll see tons of people stop their truck, get out, pull out guns that were not in a case all the time. So this is a place where the court appears to have found something as a fact about the universe. And I can say I'm not going to go through it here. This is a bit of a rush on this video because I was planning on doing this a little later with a little more detail. But I haven't been able to find anything that says that any of this was put into evidence. So this is the court essentially deciding on judicial notice that this is the way the world works. And it's not the way the world works. That's a problem. They've decided facts that are just not correct. We'll go on with more of that. A gun case is in the shape of the firearm and thus cannot be said to conceal the weapon. And here I'm going to go through and hopefully insert a little montage of gun cases on the market. As we can see, gun cases are often not in the shape of a firearm. Now they go on to cover that. It could be argued that some of the cases for carrying expensive shotguns used for skeet shooting or trap shooting competitions more closely resemble a briefcase than a gun case. Okay, good, because the gun cases that we're used to, usually those are just sort of a box shape. I say, this may be, but these cases can and should be marked clearly as the carrying case for the shotgun. A gun in a case or tightly wrapped in canvas should not be considered to be hidden or concealed. It still looks like a gun and carried in that manner does not infringe the provisions of Section 89. So here they've essentially decided that gun cases need to be labeled. This is almost... Not even almost. This is essentially the court creating a new transportation regulation. The court is not supposed to be legislating. They're supposed to be interpreting law. And at the point where they start going a step further and saying this is how things should be done, this is essentially stepping into the job of Parliament by effectively creating regulations. I have serious problems with this. I'll cover that in a little bit more detail in a moment. This stands in stark contrast with the 2016 decision in the case of the Queen and DLW. I'm not going to tell you the facts on that one. If I do, I won't just get demonetized. Somebody from YouTube is going to show up at my door with a knife. The circumstances of that case are really not pleasant. They're not family friendly. But the court took a very unpopular decision in that case because they said, essentially, we can't create new legislation. The legislation says this and only this, and we're not going to go a step further and invent new things. It was a very restrained and, in my view, very proper decision. We may not like the results of it, but I very much like it when the court knows its limits and knows to essentially stay in its lane and not step into the role of Parliament. That's not, unfortunately, what we see in the Felawka decision, because this very much sounds to me, as I mentioned, like creating new law. Going on a little, say the regulations that cause greater difficulty are those that oblige the owner to place his gun in a trunk or luggage compartment, a container that from outside does not signal to the public the presence of a gun. Recently enacted federal regulations on the transportation of firearms stipulate that a person may transport a firearm in a vehicle that is not attended only if the firearm is unloaded and either locked in the trunk or is not visible from outside the locked vehicle. Note that they're talking about a trunk here. So think about that in terms of how you drive to and from the range. In my view, this is a sound regulation whose purpose is clearly to prevent the theft of firearms from unattended vehicles. A stolen firearm can be misused and thus constitutes a grave danger to society. Compliance with this very sensible regulation should not result in a conviction for carrying a concealed weapon. Rather, it should be seen as an exception to the prohibition otherwise in place under Section 89. Think about this. The implication of this is that when it's not in an unattended vehicle, that it can't be in your trunk, that it has to be visible somehow. how is this going to be useful? We say we don't want people stealing guns out of unattended vehicles, but we want you to drive up. Let's say the unattended vehicle is you're stopping at a gas station because you need to fill up, and you also really need to use the washroom. Really bad, you just can't wait. So you've got to take the gun out of where it's visible, move it over to the trunk, or unwrap, start wrapping it up in a blanket or otherwise hiding it, and then go to the bathroom. Wouldn't it make so much more sense to just have it in the trunk in the first place? Because if somebody's inclined to steal a gun from your vehicle, watching you take the gun out of the car, open your trunk, put it in, close the trunk, and then go to the bathroom, now you've just attracted extra attention to this. I don't see how this even makes sense. I hate this case. I really hate this case. Of course, generally, regulations cannot create exceptions to their empowering acts. But, they say, there are many statutes containing provisions that permit the enabling statute to be amended by regulation with respect to its scope or field of application. Thus, frequently the nature of the delegated power is such that making a regulation necessarily entails some amendment to the statute. So they're saying that the transport regulations carve holes in the carrying a concealed firearm regulation, but only to the extent that they're commanding you to do a specific thing. And to the extent it's possible to still make it obvious that you have a gun, they want you to do it. This, again, really feels like legislation. He's rewriting the transport rules in a fashion that was entirely avoidable. Skip ahead a little further. The appellant argues that he should not be convicted of a criminal offense because he had no evil intent. That is, he had no intention to break the law or injure others. Rather, he concealed his rifle in order to avoid alarming passengers on the SkyTrain. Court says, I cannot accept this argument. It would have been so easy to have made sure that the gun was unloaded and placed in a secured gun case or wrapped and tied and then carried openly on the SkyTrain. That way, the gun would not be concealed, that is to say, hidden or disguised as something other than a gun. The fact that the firearm was enclosed would go a long way to reducing the sense of unease and alarm that would arise in the presence of a naked gun. If a gun is to be used for hunting or for target shooting, the owner should be prepared to place it in a case at the end of the day for the safety, protection, and peace of mind of all around him, which is not the law. The law does not require this at all. In fact, the end result of this decision is that you are in better shape, lawfully speaking, if you take a gun and just carry it openly on the SkyTrain than if you try to hide it in your jacket, or if you hide it in a guitar case or something along those lines. That seems like a really weird decision. And if we go back a little bit, where he was talking about how important it is to make it so it's not obvious that people can steal your gun, well, now if you're walking around on the SkyTrain with a gun clearly visible, if someone was inclined to mug you, well, that tells them this guy has something that is valuable and that can potentially be used for further crimes. If you have to walk to and from transport in a bad neighborhood, letting the local muggers know that you have a firearm on you is a great way to get mugged for your firearm. How does that help public safety? At this point, I should hopefully have another clip here. If you don't recognize these individuals, this is the tactical team, as well as their very nice vehicle, and an individual who is accused, and I assume not convicted at this stage, enjoys the presumption of innocence, of an offense that and circumstances that the tactical team thought needed their involvement. How does it improve anything if when I need to go to the range, I have to let the people know who a tactical team just removed from their house? Folks like that, I have to make apparent that I've got firearms and where they can be found. That sounds like an invitation to have my house burglarized. The other thing to consider here is that your firearms license, when you get a firearms license, it's one of the rare pieces of ID that actually doesn't include your address on it. That's not by accident. There's a reason for that. The thinking is that if somehow you lost your firearms license, and in a circumstance where you didn't also lose your driver's license, but if you lost your firearms license and somebody finds it, that shouldn't tell them where you live, because the concern that was had was essentially that somebody finds this and now they know that you have firearms and where they can go to rob you of those firearms. That's why that was left out. This is really incoherent reasoning here. Going on, I say, yet there's a situation that does give rise to concerns. The criminal law does not punish those who are morally blameless. Oh, good. Okay, maybe we'll get to something that's helping us out here. There must be a guilty mind or intent to constitute an act as criminal. What then of the accused, a resident of a sparsely populated area, returning from a hunting trip who stops on the way to pick up his young children? If he placed the firearms out of sight under the front seat in order to prevent the children from playing with them, could he be convicted of carrying a concealed weapon? I say, once again, if the firearm is placed in a gun case or wrapped in a canvas, the father would have no concerns as to the safety of his children, and the weapon would not have been concealed. Again, this really sounds like they're writing legislation. They're trying to say what ought to happen here. It is possible to imagine the unlikely situation where a firearm case or canvas was simply not available. Okay, let's see what they're saying there. In those circumstances, should a defense of reasonable excuse be available to the accused? I think not. So if you don't have a case, then what do you do? Well, obviously you can't conceal it, so you might as well leave it open to the children, I guess, is what they're arguing here. Society has a right to be protected from the very real danger of death or injury that may all too readily result from carrying a concealed weapon. It is therefore preferable that the mental element requirement be simply that the accused, knowing the object carried to be a weapon, took steps to hide it from others. The real danger of death and injury from somebody who's going to and from the range, who doesn't want to alarm their neighbors, who doesn't want to get kicked out of their apartment building, who doesn't want to create the risk that their house gets burglarized because their neighbor sees a firearm and decides, I could steal that. All of these, it's really hard to see what the risk that they're covering here. I say, similarly, the shotgun which breaks down and is carried in a case that resembles a briefcase should not be considered concealed if the carrying case is clearly marked as a gun case. But otherwise, of course, they're saying that yes, it should. I would observe that not only would guns carried in carrying cases not be concealed, but if transported in that way, they will not cause the same malaise as would a naked weapon. It takes time to open a gun case, to bring out the gun and to load and use it. That is obvious to all and will ease the nervousness produced by an uncased gun. Well, first, if you see somebody with a gun in a case, that doesn't tell you that it's unloaded. So we don't know that it's going to take time to open the gun case and bring out the gun and load and use it. And second, to open a gun case, that doesn't necessarily take a whole lot of time. That might be, if it's not locked in some fashion, that might be simply snapping it open, pulling it out, and this doesn't even make sense in a logical fashion. So now there's some dissents here, and I'll note that the dissents go in a couple of different directions. One group would have attacked this decision by essentially saying that this firearm was not necessarily a weapon under these circumstances. I'm going to cover that issue in a further video because we're already looking at more than half an hour here. The others would have required that concealment have a higher level of mens rea or guilty mind to it. such that it would have had to have been concealed for some bad purpose. So what that would mean is that if you've just bought a new handgun and you're carrying it back and it's in a case because you just bought a case and you're taking it back and that's it, you don't intend to do anything with it, you're just driving it home. That wouldn't have been concealed, not because of this complicated notion of readily obvious as containing a firearm, but simply because of the notion that you're not concealing it for a bad purpose. But if, on the other hand, you had that same handgun and you were out selling heroin and you had that handgun tucked in your jacket or down the front of your pants, that would count as concealment because now you're concealing it for a bad purpose. That would have been a much better result. I'm going to talk a little bit more about how this creates bad effects in the context of the case of the Queen and Dunn, which I intend to cover in future. One thing that I'll just mention it really briefly, which is that there are several things that count as firearms in Canadian law, but which are not what we usually think of as firearms. One of those is a nail gun. Nail gun discharges a projectile that can cause serious bodily injury or death. If you think about if you took a nail gun and held it up to the side of your head, that's going to be a life-changing move. Usually the test for serious bodily injury or death is, can it puncture an eyeball? If you think about what happens if you put a nail gun to your eye, that eye is not going to be doing very much going forward. Nail guns are exempted from being firearms for many purposes of the criminal code, which include the licensing provisions. Doesn't include carrying concealed. Technically, what this means is that a person going to a job site because they work doing construction, who throws a nail gun into their tool bag because that's just how they carry their tools, is potentially committing a serious criminal offense. One of the things I'm going to note when I mention all of this is that it's very unlikely, it's uncommon that the police will actually proceed with charges under these circumstances. But that, to my mind, is a great sign of a bad law. Because a good law, if we're saying that something is banned, it should be that all of the situations where somebody could potentially face charges are ones where we're looking at some sort of serious bad behavior, something that needs to be stopped, something that will always raise the attention of the police. Where we're talking about a law here where most of the circumstances where you will be doing something other than what the justice in this case decided should be counted as a crime, most of those situations, those supposedly criminal activities, are ones that the police won't take issue with. And that's not to say go ahead and do it, because you're at risk. The public wouldn't take issue with it. They wouldn't be upset by the notion that somebody is going to and from the gun range with a shotgun in their trunk. Most people would not be upset by that notion. They would probably be far more upset if you were taking the bus with a shotgun that's carried openly rather than one that's carried in a briefcase that doesn't happen to be labeled as carrying a shotgun. Most people, I think, would actually be quite upset by what this case seems to require, because this case essentially seems to require that you be open and notorious about your firearm ownership. I note that the RCMP gives quite opposite advice. They say, don't go and tell your neighbors that you have guns. Try to be a little discreet about this because they're worried about the break and enter aspects. This is a real sign of a bad decision, and it's a bad decision that hasn't been reevaluated. I would love to take a run at this case, but that's going to be hard to do. It's not clear if that's something that's going to be available. This is such a bad decision. As I said, I will be coming back to it on further occasions to examine more of how this is a bad decision. the negative consequences if this case, or if what this case says is illegal, was held too rigorously, would be a lot of morally blameless people being held in custody, getting criminal records, and potentially losing their ability to have firearms, but also potentially getting jail time, not being able to hold certain jobs. I'm really not a fan of this decision. But that's what we're stuck with here. And ultimately, what we're stuck with is the simple fact that he indicated he was going off on a killing spree. If he hadn't said that, I doubt this case ever would have gone to the court, because the police probably just would have given him a talking to and sent him on his way. This is also a situation where, because Mr. Felawka was essentially such a moron, the court is going to have wanted to not see him walk away without consequences. They're going to want to have condemned this bad behavior. Unfortunately, we all end up suffering when they create a bad law. There's an old maxim of hard cases make bad law. This is a perfect example. Ultimately, what they should have done is just swallow the pill of letting Mr. Felawka off the hook on this one to avoid creating this very weird decision. That's, I guess, all I have to say about this one for now. I will be coming back to this case. Please let me know in the comments what you thought of this video. Please also like, share, and subscribe if you found this useful or educational. Thank you once again for watching. This channel has experienced fairly startling growth. I've been really surprised, and I'm hoping at some point to get to a stage where I can where this will be able to be something that enables me to open up conversations with political figures and the like, but we'll see. I also want to give a thank you shout out to my $10 Patreon supporters, Stephen Larson, Process Eng, and my buddy Keith. The Patreon, if you wish to contribute, is linked below. Thank you once again.